name is Lana Elliott. I'm an immigration attorney. I have two law offices in Spokane Valley, Washington and Coeur d'Alene, Idaho. However, since immigration law is a federal law, we immigration attorneys practice immigration law in all 50 states. So I was going to talk to you today about lawful permanent residency, or what is known as a green card, how to obtain a green card, how to become permanent resident of the United States. However, this morning I read on the news that on September 8, 2022, the Biden administration released its finalized immigration policy on public charge criteria for green card applicants, which represented a significant departure from the interpretation of the public charge of the Trump administration. Unfortunately, under the Trump administration, many applicants for the green card became ineligible to receive that benefit. And this public charge interpretation is very welcome in our immigration community. So first, I would like to provide you with some background information on the public charge, what it is and why it's important for immigrants and potential immigrants to know this concept and its ramification. So in general, to become a lawful permanent resident of the United States, or in other words, to obtain a green card, a person must be admissible. Admissibility is a legal term, which basically means that the prospective immigrant must pass the test of being a good person or being fit to live in the United States, in the American society. Related to admissibility, there is a term called inadmissibility, which means that the immigrant is found to be inadmissible, they cannot obtain their green card. So what are the grounds for inadmissibility? First of them is being convicted of a certain criminal offense. Second one, having some significant health issues, but not just having like heart issues or kidney problems, but having a contagious disease. The American society is concerned about contagious diseases, so they make sure that potential immigrants don't bring those issues into this American society. Most of the time, those issues can be resolved easily, usually by an immigrant completing a special treatment, for example, for an active tuberculosis. So the tuberculosis becomes inactive and then the person can safely come to the United States without creating any hazards to its citizens. There is also potential ground for inadmissibility. It's immigration violations in the past. For example, a person who came to the United States without documents, reside here for some time, more than a year, and then returned to his home or her home country, and then again came to the United States without documents. So when that person applies for a green card, they must spend 10 years outside of the United States. It's absolutely mandatory before they're allowed to become US permanent residents. And there is such a ground of inadmissibility as public charge. That's what we're going to talk today about. So public charge means that the immigrant has been, is, or likely to become a public charge in the future, which means that immigrant has been dependent, is dependent, or likely to will be dependent on the government assistance for their financial maintenance. If the government determines that the immigrant is public charge, it will not allow them to become permanent residents. However, the most important question is how to interpret it. What's the interpretation of public charge? What kind of benefits make a person to be a public charge and which ones don't? Also, what about family members? For example, a potential immigrant has a child who is a US citizen, and child receives cash assistance, food stamps, and probably Medicaid or some other health benefit related or run by the state. So does it make the immigrant public charge as well? As you probably see, it's all a matter of interpretation. So for a long time, since 1999, we operated under the so-called field guidance that directed immigration offices to interpret the phrase public charge, referencing to those who are likely to become primarily dependent on the federal government. And that's important to understand that the key phrase is primarily dependent on the federal government. However, the Trump administration had made significant changes to this interpretation. It issued a new policy widening the interpretation to include immigrants who have used other government assistance programs, including housing and health care subsidiaries. So under the Trump administration, we immigration attorneys had to fill out a form that's called Declaration of Self-Sufficiency, and we had to ask our clients about their financial health. For example, we had to ask them about their education, their employment skills, their ability to speak English, their assets like money in a bank or ownership of a house, because based on that information it was determined if the person will become a public charge or not. This policy was absolutely anti-humane, and as expected it was widely criticized by immigrant advocates, which resulted in filing a lawsuit against that policy. That lawsuit went all the way up to the Supreme Court. However, before the justices made a decision, President Biden took office. President Biden lived up to his promises, and on February 24th, 2022, USCIS issued a notice of proposed rulemaking in public charge and accepting public comments until April 25th, 2022. Once the public comment period ended, the president was supposed to make the final rule, to finalize that policy. So on September 8th, the Biden administration released its finalized immigration rule. It's 455 pages, and it's set to take effect on December 23rd, 2022. So the most important part of this new finalized rule is that potential immigrant will be considered public charge only if they receive public cash assistance for income maintenance or long-term institutionalization. So the most important terms are cash assistance and long, not just short-term. Short-term doesn't qualify, but long-term institutionalization at government expense. In the news release, Homeland Security Secretary Alejandro Mayorkas said, "Consistent with America's bedrock values, we will not penalize individuals for choosing to access the health benefits and other supplemental government services available to them." In my next presentation, I will explain three things. First, who is exempt from the public charge ground of inadmissibility? Second, which public benefits will be considered by USCIS in determining whether the applicant is going to be public charged or not. And the third one is which public benefit programs USCIS will not consider in determining the public charge. So stay tuned.